A December court decision just shattered everything gun owners thought they knew about their Second Amendment rights, and the shockwaves are spreading fast across America, with 10 major gun laws now completely transformed overnight, leaving millions of firearm owners scrambling to understand what this means for their constitutional freedoms, because what the courts just ruled goes against decades of established precedent and could criminalize what you're doing right now with your legally owned firearms, whether it's concealed carry restrictions being flipped on their head or magazine capacity limits suddenly becoming unconstitutional, or perhaps the most controversial aspect involving red flag laws and due process that has both sides of the political divide absolutely furious. And if you own a gun or care about constitutional rights, you need to smash that like button and subscribe right now, because we're breaking down all 10 laws that just changed, and I'm telling you that final revelation at the end about what this means for federal enforcement is going to leave you absolutely stunned, so stay until the very end. Law number 1. Ghost gun regulation upheld. Let's start with one of the most controversial decisions of 2025. On March 26th, the Supreme Court handed down its ruling in Bondi versus Vanderstock, and it represents a major turning point in the ghost gun debate. In a 7-2 decision, Justice Neil Gorsuch, writing for the majority, upheld the ATF's 2022 rule regulating ghost gun kits, those do-it-yourself firearm assembly packages that can be bought online without serial numbers or background checks. Here's what makes this absolutely critical. The court ruled that the Gun Control Act of 1968 allows the ATF to regulate weapon parts kits that can readily be converted into functional firearms. We're talking about those so-called 80% frames from companies like Polymer 80 that law enforcement says have been flooding crime scenes across America. According to ATF data, ghost gun recoveries skyrocketed from 1,600 in 2017 to over 27,000 in 2023. That's a 1,700% increase in just 6 years. The ruling means that sellers of these kits must now obtain federal firearms licenses, add serial numbers to the parts, and conduct background checks on buyers, just like traditional firearms. Justice Gorsuch emphasized that the statute's plain text covers any weapon designed to expel a projectile or can readily be converted to do so, and many of these kits, which can be assembled in as little as 15 minutes with basic tools, clearly meet that definition. The dissent from Justices Thomas and Alito argued the ATF overstepped its authority, but the majority disagreed. Data from Los Angeles shows ghost gun recoveries dropped by 50% after the rule took effect, proving it's working. However, there's uncertainty ahead because Trump's Justice Department has been reviewing all Biden-era gun regulations, and they could still choose to rescind this rule despite the Supreme Court upholding it. Law number 2. Illinois assault weapons ban struck down then reinstated. Now let's talk about what happened in Illinois, and this one is a roller coaster. On November 8, 2024, U.S. District Judge Stephen McGlynn issued a 168-page ruling that sent shockwaves through the gun control community. He declared Illinois' Protect Illinois Communities Act, which bans assault weapons and high-capacity magazines, unconstitutional under the 2nd and 14th Amendments. This law passed in January 2023 after the Highland Park 4th of July parade massacre that killed 7 people, banned dozens of specific assault-style weapons, including AR-15 rifles, restricted magazine capacity to 10 rounds for long guns and 15 for handguns, and required existing owners to register their weapons. Judge McGlynn compared firearms used for self-defense to lifeboats and airbags, arguing that banning commonly owned weapons deprives citizens of their principal means of self-defense. He wrote that it's particularly disturbing that weapons commonly owned and used by law-abiding citizens are now banned. The state had 30 days to appeal. But here's the twist. On December 5th, just days before McGlynn's order would have taken effect, the 7th Circuit Court of Appeals issued a stay, keeping the ban in place pending full arguments. The appellate court noted that weapons covered by Illinois' ban are more like machine guns and military-grade weaponry than firearms used for individual self-defense. They also pointed out that courts can't let laws be valid in some parts of Illinois and invalid in others. Meanwhile, there's a similar case challenging Maryland's assault weapons ban that could go to the Supreme Court. And if the justices take that case and rule against Maryland, It could effectively invalidate assault weapons bans across the entire United States. Gun store owners in Illinois say the ban has devastated their business, while gun safety advocates insist it's saving lives. This legal battle is far from over, and the ultimate decision could reshape gun ownership for millions of Americans. Law number 3. New York's private property gun ban overturned. Moving to New York, where another bombshell decision came down. On October 10, 2024, U.S. District Judge John Sinatra Jr. struck down a key provision of New York's Concealed Carry Improvement Act. This law, signed by Governor Kathy Hochul in July 2022 after the Supreme Court's Bruen decision, made it a felony for concealed carry permit holders to bring firearms onto any private property, unless the owner expressly allowed it through signage or verbal consent. Judge Sinatra ruled this blanket ban on private property open to the public, like grocery stores, gas stations, and shopping malls, violates the Second Amendment. The judge emphasized that property owners absolutely have the right to exclude firearms from their property, but the state cannot unilaterally exercise that right and interfere with the long-established Second Amendment rights of law-abiding citizens seeking to carry for self-defense. The ruling shifts the burden. Instead of a default ban requiring opt-in permission, property owners must now actively opt out with clear signage if they want to prohibit firearms. The decision was based on the Supreme Court's Bruen standard requiring gun regulations to be consistent with the nation's historical tradition of firearm regulation. New York tried to justify the ban with historical examples from the 1700s and 1800s, but Judge Sinatra found these were narrow laws targeting hunters and trespassers, not broad public safety measures. Governor Hochul and Attorney General Letitia James vowed to appeal, with Hochul claiming the law has made New York one of the safest states in the nation. Gun rights groups celebrated this as vindication that New York's post-Bruen restrictions are unconstitutional. Plain and simple. Law number 4. Federal handgun purchase ban for 18 to 20-year-olds declared unconstitutional. Here's where things get really controversial. On January 30th, 2025, the Fifth Circuit Court of Appeals issued a unanimous decision in Reese versus ATF that's going to change gun purchasing across the country. The court struck down the federal law requiring individuals to be 21 years old to purchase handguns from licensed dealers. This is a law that's been on the books since the Gun Control Act of 1968, and now it's gone. Judge Edith Jones, writing for the 3-judge panel, found that the plain text of the Second Amendment protects 18 to 20-year-olds because the phrase "the people" refers to all members of the national community, not some arbitrary subset based on age. The court rejected the government's argument that young adults weren't part of the political community at the founding because they couldn't vote. The ruling emphasized that there are no age or maturity restrictions in the actual text of the Second Amendment, and the right to keep and bear arms necessarily implies the ability to acquire them. The government presented scant evidence that 18 to 20-year-olds' firearm rights were restricted in a similar manner during the founding era. What makes this particularly significant is the circuit split. While the Fifth Circuit struck down the age restriction, the 10th Circuit upheld Colorado's age 21 purchase requirement just months earlier in November 2024, and the 11th Circuit upheld Florida's similar law. 3 different federal appeals courts reaching 3 different conclusions means this issue is almost certainly heading to the Supreme Court. Gun control advocates are furious, pointing to FBI statistics showing that 18 to 20-year-olds commit gun homicides at triple the rate of adults 21 and over, and that firearms are the leading cause of death for children and teens. Everytown for Gun Safety called the ruling reckless and warned it undermines crucial public safety measures. Gun rights groups celebrated, with the Firearms Policy Coalition calling it a victory against an immoral and unconstitutional age-based gun ban. The Trump administration is expected to be far more sympathetic to gun rights than Biden's Justice Department, which fought these rulings. This case perfectly encapsulates the post-Bruen landscape, where historical tradition matters more than modern public safety statistics. Law number 5. Drug users and gun rights. The Supreme Court takes the case. This next one involves a federal law that convicted Hunter Biden, and it's now before the Supreme Court. On October 20th, 2025, The justices agreed to hear United States versus Hemani, which challenges whether the federal ban on gun possession by habitual drug users violates the Second Amendment. The law in question, Section 922G(3) of the Gun Control Act, prohibits anyone who is an unlawful user of or addicted to any controlled substance from possessing firearms. The Fifth Circuit Court of Appeals ruled this ban unconstitutional as applied to marijuana users in multiple cases, including Daniels and Connolly. The Fifth Circuit found that historical evidence only supports disarming people who are actively intoxicated or under the influence at the time, not categorically banning anyone who habitually uses drugs. They compared it to old laws about common drunkards, which were temporary and context-specific, not permanent categorical bans. In the Hemani case, the defendant is a dual citizen of the U.S. and Pakistan who had marijuana and cocaine at his home, along with a pistol. The Trump administration is defending the law, which is ironic given their general pro-gun rights stance. Solicitor General D. John Sauer argues the ban complies with the Second Amendment because it targets habitual users of unlawful drugs who pose a clear danger of misusing firearms. And it's only temporary because anyone can restore their rights by simply stopping drug use. But here's the controversy. Nearly half of U.S. states have legalized recreational marijuana, and millions of Americans who legally use cannabis under state law are still violating federal law and thus prohibited from owning guns. The Eighth Circuit pointed out the absurdity, asking about the 80-year-old grandmother who uses marijuana for a chronic medical condition and keeps a pistol for safety. Is she really a public menace who must be disarmed? The Supreme Court's decision in Rahimi last year upheld restrictions on domestic abusers, but that involved individualized court determinations of danger. The drug user ban is categorical, with no individual assessment. This case will determine whether millions of marijuana users, both medical and recreational, can legally own firearms. A ruling is expected by summer 2026, and it could have massive implications for both gun rights and drug policy. Law number 6. Concealed carry on public transit struck down. Let's talk about a decision that's gotten less attention, but affects millions of Americans who use public transportation. In September 2024, a federal district court judge in northern Illinois ruled that the state's ban on carrying concealed firearms on public transit violates the Second Amendment. This ruling came as part of the broader challenge to Illinois' post-Bruen gun restrictions. The law prohibited concealed carry permit holders from bringing firearms on buses, trains, subways, and other forms of mass transit, with supporters arguing that crowded public transportation presents unique safety concerns. However, the court found that the state failed to demonstrate a historical tradition of disarming law-abiding citizens in similar transportation contexts. The judge noted that while certain sensitive places like courthouses and schools have deep historical roots as gun-free zones, public transit is a modern invention without clear founding-era analogs. The state tried to argue that public gathering places have historically been restricted, but the court found these examples too different from the daily commute millions of Americans make on buses and trains. This decision is particularly significant for urban areas where public transit is essential for getting to work, and where many law-abiding citizens want to carry for self-defense, but were being forced to choose between exercising their Second Amendment rights and using public transportation. Gun control advocates worry this will lead to more guns in crowded spaces where confrontations can quickly escalate, while gun rights supporters argue that criminals were never following the ban anyway, and law-abiding citizens deserve the right to protect themselves wherever they go. Law number 7. The Sensitive Places Doctrine under fire. The seventh issue involves what courts call sensitive places, locations where governments have traditionally been able to ban firearms. After the Supreme Court's Bruen decision in 2022, states rushed to expand their lists of sensitive places to include parks, libraries, theaters, bars, and even places of worship. New York's Concealed Carry Improvement Act was the most aggressive, essentially trying to make everywhere except a few designated areas off-limits to guns. But courts are pushing back. The Second Circuit Court of Appeals in December 2023 and again in October 2024 upheld many of New York's sensitive place restrictions, including schools, government buildings, public transportation, and healthcare facilities. However, they struck down the blanket ban on private property open to the public, finding it went too far. The court emphasized that sensitive place restrictions must have strong historical analogs, not just be places where the government thinks guns would be dangerous. What's emerging is a narrower definition of sensitive places than gun control advocates hoped for after Bruen. Courts are requiring specific historical evidence that particular locations were restricted at the founding, and they're rejecting broad arguments about modern public safety concerns. The Third Circuit noted in the Range case that determining which places qualify as sensitive is one of the most contentious issues in Second Amendment litigation right now. Governor Kathy Hochul claimed that personally. She thinks every place is sensitive, but courts aren't buying that argument. The sensitive places doctrine will continue to be litigated aggressively, with gun control states trying to preserve as much authority as possible to restrict carrying, while gun rights groups push to narrow these exceptions to only the most traditionally restricted locations like courthouses and polling places on Election Day. Law number 8. Red flag laws and due process concerns. Number 8 involves extreme risk protection orders, commonly called red flag laws, and they're facing new constitutional scrutiny. These laws allow family members, law enforcement, or in some states, medical professionals, to petition courts to temporarily remove firearms from individuals deemed a danger to themselves or others. 19 states and the District of Columbia have red flag laws. The Supreme Court's Rahimi decision in June 2024 provided some support for these laws by upholding restrictions on domestic abusers subject to restraining orders. But Justice Roberts emphasized the importance of individualized judicial determinations and due process protections. What's happening now is courts are examining red flag laws more carefully to ensure they provide adequate procedural safeguards. The concerns include: are individuals getting sufficient notice and opportunity to be heard before their guns are seized? How long can temporary orders last without a full hearing? What's the standard of proof required? And can individuals effectively challenge wrongful orders? Gun rights advocates argue many red flag laws suffer from vague standards like being a danger to self or others without defining what that means, allowing ex parte orders where guns are seized before the person has any chance to respond, and lacking penalties for false or malicious petitions. Gun safety advocates counter that these laws save lives by intervening in crises before tragedies occur, and point to studies showing reduced suicide rates in states with red flag laws. The constitutional fight centers on balancing the government's interest in public safety against the Second Amendment right to keep and bear arms and Fifth Amendment due process protections. Expect this to be a major battleground as more states consider adopting red flag laws and existing laws face challenges. The key question is, can these laws be crafted with sufficient due process protections to survive constitutional scrutiny? Or do they inherently violate Second Amendment rights by allowing gun confiscation based on predictions of future dangerousness rather than past criminal conduct? Law number 9, bump stock ban reversed. In June 2024, the Supreme Court delivered another major gun rights victory when it struck down the federal ban on bump stocks in Garland versus Cargill. Bump stocks are devices that allow semi-automatic rifles to fire more rapidly by harnessing the recoil energy to bump the trigger against the shooter's finger. The ATF banned them in 2018 after the Las Vegas massacre, where a gunman used bump stock-equipped rifles to kill 58 people and wound hundreds more. The ATF classified bump stocks as machine guns under the National Firearms Act, arguing they allow a rifle to fire more than one shot with a single function of the trigger. But the Supreme Court, in a 6-3 decision written by Justice Clarence Thomas, ruled the ATF exceeded its statutory authority. The majority held that bump stocks do not convert a semi-automatic rifle into a machine gun as defined by federal law, because each shot still requires a separate pull of the trigger, even if the bumping action makes this happen very quickly. The shooter must continuously maintain forward pressure, making it more like pulling the trigger very fast than true automatic fire. Justice Sotomayor's dissent, joined by Justices Kagan and Jackson, argued the majority ignored the reality that bump stocks produce the same practical effect as machine guns, firing hundreds of rounds per minute, and said Congress clearly intended to ban such devices when it prohibited machine guns. Gun control advocates were devastated, seeing this as the court prioritizing technical definitions over common-sense safety measures. Gun rights supporters celebrated, arguing the ATF can't rewrite statutes through regulatory interpretation. The practical impact is bump stocks are now legal again unless Congress passes new legislation specifically banning them, which seems unlikely in the current political climate. Manufacturers have resumed selling these devices, and there's nothing stopping another Las Vegas-style attack using legally purchased bump stocks. Law number 10. Non-violent felons can challenge gun bans. And now for the final revelation that will leave you stunned. The one I promised would change everything. Multiple federal circuit courts have ruled that non-violent felons can challenge their lifetime gun bans on a case-by-case basis, opening the door for millions of Americans with criminal records to potentially restore their Second Amendment rights. The Third Circuit's decision in United States versus Range in 2023 started this avalanche. Brian Range, who pleaded guilty in 1995 to making a false statement on a food stamp application, a nonviolent felony, successfully argued that the federal felon in possession ban is unconstitutional as applied to him. The court found no historical tradition of permanently disarming nonviolent offenders. The Fifth Circuit in United States versus Diaz held that the government must prove its application of the ban is consistent with America's long-standing tradition, and found that only offenses that were capital crimes at the founding justify permanent disarmament. The Sixth Circuit in United States versus Williams ruled that felons must have an opportunity to prove they're not dangerous. Over 1,000 felons have challenged their gun bans since Bruin, and courts are increasingly distinguishing between violent and non-violent offenses. Justice Amy Coney Barrett, when she was on the Seventh Circuit, wrote a dissent supporting restoration of gun rights for non-violent felons, and she's now on the Supreme Court. Here's the bombshell. The Trump administration's Justice Department is now working to revive a long-dormant federal program under Section 925C that allows certain individuals with felony convictions to petition for restoration of their gun rights. This program was effectively shut down in 1992 when Congress stopped funding it, but it was never repealed. Attorney General Pam Bondi published a proposed rule in 2025 to restart the program. The DOJ estimates over 25 million people could potentially qualify to apply. The proposed framework would presumptively exclude violent felons, registered sex offenders, and illegal immigrants, but would allow non-violent offenders who have completed their sentences and demonstrated they're not dangerous to petition for relief. This is a massive shift. For decades, a felony conviction meant a lifetime gun ban with virtually no possibility of restoration at the federal level. Now, the door is opening for individualized review. Critics warn this could return firearms to dangerous individuals and undermine public safety. Supporters argue it restores due process and recognizes that not all felonies are equal in terms of dangerousness, and that people who have paid their debt to society and proven rehabilitation shouldn't be permanently stripped of constitutional rights. This is happening right now. And if you or someone you know has a nonviolent felony conviction, 2025 and 2026 could be the years that Second Amendment rights are restored. That's why criminal defense attorneys and Second Amendment lawyers are seeing an explosion of interest in gun rights restoration cases. Before you go, listen carefully. The gun laws you knew last year are not the same ones in effect today, and by next month, everything could change again with more court decisions pending. If you don't stay informed, you could unknowingly violate a new restriction or miss out on newly restored rights that directly affect you. This is why you absolutely must subscribe to this channel and turn on notifications so you don't miss a single update, because I'll be breaking down every major ruling the moment it drops. Share this video with every gun owner you know, because this information is too critical to keep to yourself. Your Second Amendment rights are being rewritten in courtrooms across America right now. And ignorance is not bliss when it comes to federal firearms law. I'll see you in the next video where we dive even deeper into what's coming next. Stay armed, stay informed, and stay legal.